So the first question is asked by a lady by the name of Berenice Adriansa, and she wants to know, she says that her mother has purchased a house, and that house has a granny flat attached to it. She says that her mum moved in last week and then discovered that the roof in this particular house and granny flat was leaking. They also found out that there were leaks in both bathrooms, and that the water of the granny flat, well, I'm assuming that the downpipe, it doesn't run into the drain. So that's obviously causing some issues with regard to the structure of the building. She says that there's already a few issues on the property itself that were not disclosed to her mum when her mother purchased the property. And her mother's already taken, the responsibility of replacing a few items here and there within the house. She wants to know that, what are the chances of her mum claiming or reclaiming these costs that her mum has already spent, as well as the possible damages that might, have been incurred from this rain that happened recently. Can she claim it from the seller for non-disclosure? And then secondly, she wants to know that should the seller have obtained a plumber to, issue a certificate that says that all the plumbing is in order. So I think let's start with Cilna on this one, and then Bruno, over to you.
Cool. Cilna, and then to Bruno. I get you. Okay, so this is going to go around Voetstoots. So the fact that they've purchased the property and now they are realizing that there are defects to the property. It's a little difficult to answer the question without seeing the offer to purchase, because the truth is, as much as we always say, there's a general set of answers and principles in law. When it comes to especially sale of property, your offer to purchase is very relevant, because the general rule would be, if the property was purchased Voetstoots, it means Voetstoots means you buy it, and whichever condition it's in, that's the way it's going to be. The seller doesn't have to change or fix anything. The thing about Voetstoots that's very important is there are major difference between latent and patent defects. Now, I won't bore our viewers with going into all the detail around latent and patent defects, but the short version is, if a seller purposefully hides something, Voetstoots won't cover that. The fact that the ceiling is basically 2 seconds from collapsing, and now you're making a plan, nee? A boer maak 'n plan. A lot of other people as well, but this is a traditional saying. And if you suddenly you quickly sand the ceiling and you paint it white and the world looks perfect, but for a fact that thing is going to collapse any second now. Purposefully hiding defects won't be covered by Voetstoots. You can still claim those damages from the seller thing. However, a defect that really the seller did not know about this. For instance, termites, and I know termites tend to be a major issue. It's not part of this question, but termites could be very far. The problem can be pretty impressively advanced without anybody knowing about it. By the time you notice termites, it's usually at that point. In those circumstances, there's no way you're going to hold the seller liable. Now, in this instance, it's a granny flat, and it seems like the issues around the property isn't limited to the granny flat, but it seems to center around the granny flat. Now, the truth is, it could be a very bona fide mistake from the seller to not be aware of those leaks, because they're not necessarily in the granny flat as often as they are in the main building. And it could very well be a defect that the seller is unaware of. And in those circumstances, Voetstoots will be applicable, and the purchaser won't have a claim against the seller. Time is also relevant. I mean, if transfer took place a year ago, even though we were in lockdown, remember good times last year, this time we were sort of coming out again already, like little butterflies. But even with COVID in mind and lockdown and all the regulations, you still had time to act on something. So if a transfer took place a year ago, and you're noticing these defects now, it's not something you're going to be able to hold the seller liable for. But also keep in mind, and now I'm sorry for all the sellers and the estate agents, please don't stone me. But in terms of the Consumer Protection Act, if there was an intermediary involved in a transaction, in this situation, it would be an estate agent. There's an obligation on the seller of the thing, whatever it is, to sell a thing that is in good working order and condition. And the ideal situation would be to have a landlord disclosure form. I recommend, however, that you have options on your landlord disclosure form, your seller disclosure form, not just, is the ceiling in this room good and well? It should be yes, no, or I don't know, maybe. A seller can't give an undertaking that the ceiling and all the things in the ceiling is in good working order and repair, unless you get an awesome inspector out to do the inspection for you. You can't disclose. So rather say, I don't know. That safeguards the seller in the sense that if there is suddenly that goes haywire completely, at least you didn't purposefully fail to disclose that. So in this particular case, if there was an agent, and in that case, in a case where the CPA then does apply, and there was the property was sold Voetstoots, but we can show that the seller must have been aware of this leak or all the problems that there is. There could be a chance of claiming damages from the seller, but I need our viewers to understand, by the time you take transfer of a property, to try and go back and claim damages from the seller, you can have an uphill battle on a whole new level. Make sure before you take transfer of a property that everything is in fact in good working order and repair. And I do recommend every single day of the week, whether it's an investment property or for primary residence, get a proper registered property inspector out to inspect the property on your behalf, because you're going to look at the garden is pretty, and you're going to think like, oh, I can see myself in this living room, or whatever your thing is. Get somebody out that isn't getting emotionally attached to the look, but will actually inspect the property for defects. And I'm not a property inspector. Our joint good friend is a very good property inspector, and she will get into roofs and inspect every angle of a property in a way that even very well experienced property lawyers won't be able to.
Oh, thanks, Cilna.
Pleasure.
Bruno, if there's anything you want to add to that, otherwise we'll just move quickly on to the next question.
So just a very quick one on the application of the CPA. Maybe just to add on what Cilna was referring to. Remember, the CPA would apply in two circumstances. Number one, the estate agent acting as an intermediary. That's what Cilna was specifically referring to. Certain disclosures need to be made, but obviously people aren't always aware, so you can try pass certain forms of liability or responsibility onto a purchaser up to a certain degree. If the CPA, however, applies to the sale, so it's two very different concepts: the relationship with the estate agent and acting as an intermediary versus the actual relationship with the seller. If the seller is a person that trades in properties in the course of their business, and it is found that the CPA applies to that transaction, then there are certain warranties almost that the CPA it puts on the transaction where a purchaser may have recourse against the seller. So what a person will need to look for in these circumstances is specifically a seller that does this as his business. Because if he does, the same rules that typically apply to buying a car and there being defects in a car when you buy it from a dealer. Those same rules would apply to the sale, and the purchaser would have that recourse. And that's why we always raise the example, for instance, of sales and execution and auctions, where it's made very express that although this Consumer Protection Act applies, certain regulations and general common law principles are tapped in, where in auctions, people, especially sales and executions that from the sheriff, neither the sheriff nor the bank actually have any idea what the condition of this property is. And you need to know that. And when you buy it, you take full responsibility, because there is no implied warranty at all, and no protection by the Consumer Protection Act, or limited protection rather, if for instance, in those circumstances.
Thanks, Bruno. Okay, so we'll swiftly move on to the next question, which was asked by Megan Volmerans. And Megan wants to know, she says, hi, I live in a sectional titled double-story complex. The first floor units have small outside balconies, but no awnings. There has been a request to build awnings for the 10 first floor balconies from the body corporate funds. I am not in favor of this, as I feel my ground floor unit will not benefit from this upgrade at all, but that the money to be used for the upgrade will come from the funds that I contribute through my levies. Megan wants to know, what is my recourse? And, should I wish to object this, what can I do? She does mention that, the trustees have suggested that a vote is taken on this subject, but she believes that the vote will obviously not be in her favor, as the owners who actually are going to have these awnings built are going to vote in favor of it. What advice can we give to Megan, Bruno?
Look, it's a bit of a difficult one, because it comes down to what's reasonable and what's not reasonable. Typically, body corporates are effectively run the same way that one would run a country, in a democratic country at least, right? You have a whole bunch of people put together. They elect representatives or people that execute their decisions. These trustees, which are basically the executive, or like the executive, they run the day-to-day operations. They make certain decisions that they have a mandate to make, and most other decisions have to go back to the owners. And you can have these decisions like special meetings or annual general meetings. So in circumstances like this, if you apply it across the board, whatever decision needs to be made, one does need to look at whether this decision falls within the ambit of the trustees or falls within the ambit of the other owners, right? That's the first question. Now, this isn't really an operational decision. This is almost improvements or renovations. So typically you'd find that this would go for a decision around the owners. Now, unless it's stated otherwise, if memory serves me correct, something like this would probably be a normal resolution as opposed to a special resolution. Cilna can correct me if I'm wrong. I can't for the life of me remember on this, like these specific type of things. But if it is a special resolution, it would be a majority rules situation, where now it really depends on how many people are getting it, how many people aren't getting it, and the vote under those circumstances. But now what we also need to remember is, because of our legislation, there's certain protections that come along with this. So just because, and it happens very, very often, where you'd have, for instance, one owner or a developer that stored a whole bunch of properties, and he keeps getting the majority vote, or a huge amount of the vote. So he controls everything, and he doesn't necessarily always take care of the best interests of the other owners. He's very selfish on his own units. And even in those circumstances, there is recourse where you can go to the ombud. So CSOS basically, and you can approach them with a complaint, and they've got certain powers, so they can review certain decisions, they can review certain rules that are made based on either invalidity or what's reasonable, and they can make decisions based on that. So if it's found that this was an unreasonable decision because it only I don't know, it benefits a very few amount of people, but you know, for some reason they have the vote, so they manage to push the vote through. That's one thing. But if it's pretty evened out, you could argue potentially that is for the like it's the best for the building. And if there's an argument to be made of that, maybe it could be allowed. But yeah, the vote is pretty much the first step to this. You'd have to first take the vote and just see how many people are for it, how many people are against it, and why. And you'd have your opportunity to give your reasons. But remember, because you've chosen to give up certain rights by living in this community, this is just one of those rights that unfortunately you can get outvoted on, and you just kind of need to live with it.
Yes, I think Bruno, what's important to note as well for the viewer, remember an awning on a balcony will potentially change the structure of the unit to the point where instead of this being a balcony, which is like an outside thing, still part of the unit, but it's a balcony that's not enclosed. The moment you enclose a balcony or a patio or whatever in sectional title, you need consent from the surveyor general. And the moment that happens, where you enclose in any way, it means you're changing the square meterage of the actual unit, which has a direct impact on the participation quota. Now remember, your levies are calculated on your PQ. So I don't know what these awnings will specifically do to this specific unit. But if it does have the effect of enclosing the patios to the point where it now forms part of the unit, it will impact the PQ, which could actually be more beneficial to your ground floor. That the language center ran out. Let's stick to one language still, not English. Okay, so where your ground floor owners then doesn't have this benefit, they maintain their normal PQ, where the rest of the place, the guys that's scoring from these awnings now, if it does enclose, it will increase their PQ, which means effectively what I'm saying is they're going to pay more levies than you. So don't just look at but it's not going to be a direct benefit for me because I'm not being awninged. That's a term. I'm not receiving any benefit. Remember, you could have a much bigger financial benefit going forward because of this. So, Bruno, to your point, I support exactly that. If the vote is in favor of the awnings, please just don't go and vote without having the full facts. Understand how this will impact the PQ. Understand how the impact of the PQ will affect your levies. And there could be a major benefit even though you are not receiving something cool.
Oh, thank you, Cilna. Thank you, Bruno, for that. I'm going to quickly move on to the next question, which was asked by a lady with the name of Chanel Pretorius. And it's also around a similar thing, you know, with sectional title. And she wants to know, she says, good day, I got contacted by my managing agent from my sectional title with regards to a vote that needs to take place to decide a financial matter. She says, in 2014, the trustees signed a contract for a loan to the value of 250,000 Rand from a financial institution to cover arrear levies. She says that we were informed in January 2021 that the financial institution wants the body corporate to repay the loan, as they are now charging almost 6,000 Rand in interest a month on that loan which was taken out. She wants to know, does the trustees alone have the power to take on a loan that is that large for that amount? And she's worried that we as owners, she says, will now have to repay this loan out of our own pockets. How can owners be held responsible for, you know, other arrear levies? That's what she writes. I think Cilna, maybe you want to tackle this one first, please.
I'm going to do my best to tackle this one without getting upset about it. Because if there's one thing that really upsets me is sectional title owners really ending up on the wrong side of a loan, because once again, democracy will always have the impact that some people will take quick right now benefit decisions, which is then in the form of a loan, and then everybody else has to deal with the interest at a later stage. The truth is, and I'm sorry for offending 79 people now, I'm saying in advance I'm going to offend people. Loans in sectional title is the ultimate thing that people made money from over the past, well, since sectional title's been around. The problem with that is many body corporates sell their debt books to collection companies, which is all good and well. But the problem is usually that runs with a loan. So the body corporate doesn't just get the benefit from selling their debt book, there is a loan attached to that. And the truth is, those loans and the interest rates that they are typically running on is to the point where no body corporate can get out of that kind of debt without serious focus from all the owners. And usually you won't get that because most owners doesn't understand the financial benefit in future of biting the bullet now and getting rid of that debt. They add more debt because the levies are too low and the collection rate on the levies are too low. So now they're living off loans, and this is pretty much somebody living off credit in his personal capacity. You can't get out of that debt trap, and it's even worse in levy collection situations in sectional title, where the owners can't pay the levies for the stuff that they want. They want 24-hour security. They want a new fresh coat of paint every 3 years. They want garden services to have like freshly manicured lawns every single week. These things cost money. And the problem is, if an owner doesn't understand, your levy will always equate to the value that you're getting from the body corporate and from the sectional title unit. It means they're expecting stuff that they can't afford. It's similar to going out to buy the R1 million car because it's pretty, but actually you can only afford a car for 300,000 Rand. People in sectional title complexes live above their means, and unfortunately there are companies that's able to provide credit that, for lack of a better word, is actually taking the benefit from these interest rates that they are charging body corporates to the extreme detriment and serious harm to the uninformed owner in the sectional title complex. So that was my little rant. Answer to the viewer is, unfortunately, if the body corporate decides, if there's a vote, and the scary part is every single time in every single AGM where there's a vote to increase the loan to the sectional title, the majority of the owners will vote in favor of the loan, because people does not understand the actual drama they drop themselves in when they are stuck in credit. And body corporates can't get out of these debt situations because owners vote for more and more and more credit. And unfortunately, if you don't want to be liable for the debt of previous owners, you need to make sure when you buy into a sectional title scheme that you do due diligence to the point where you go back and you get the AGM minutes of about 2 or 3 years back to see how comfortably this body corporate makes decisions. And if there is a loan, to be honest, I won't buy personally. I will not buy a property in a sectional title complex where there's an existing loan or high arrear levies without an actual plan. And your managing agent is crucial. If you have a managing agent that also runs a credit service on the side that will tie The credit in with this must now be your managing agent. Run, far, for long. I didn't help this viewer at all. Bruno, don't you want to, take over from my rant so you can actually answer the viewer's question?
Cool. But well done. Well done. At least you set the landscape for what, like the red flags, what to look out for.
All of them. Credit.
So fortunately, so I think it's Section 4, if I'm not mistaken. Now I can't remember, but there are certain provisions that deal with the acquisition of loans by body corporates, and if memory serves me correct, I can't remember the section. I'm going to lie to you. I think it's 4, but specifically requiring a special resolution to be passed before a loan is actually taken out by a body corporate. So this means that it's not within the ambit of the trustee's powers to take out a loan. So that answers a portion of the viewer's question. It has to go to the owners. It's not a majority rule. It's extraordinary rule. So it's a special resolution. So that's a far, far higher number. So but going back to Cilna's point.
Sorry, Bruno, 75% in favor, right?
Yeah. But now going back to Cilna's point, the problem now with asking a room full of people to make a decision on a loan that gives them some level of short-term gratification is exactly the issue that we're experiencing throughout our country, and just general lending. That's how microloans have become so popular, because you buy things that you shouldn't be buying, that you can't afford because it feels cheap, because it seems like you're paying very little over a long period of time, but it's not really the case. You'll end up paying back double, triple. With microloans, it's a stupid amount. So to the viewer's point, can it be done? It has to be done in a specific way, right? Are these members or these homeowners actually knowledgeable enough, or clued up enough, rather informed? Are they well informed to actually be able to make this vote? That's a completely different question. And I think the approach isn't so much a legal approach as it is more an education approach, giving examples on how bad something like this could be. Taking out credit works. There's good credit and bad credit. And unless this is a short-term plan with an outcome, like a business rescue plan, it just doesn't make sense, because long-term credit to try to fix a situation where you have defaulting owners makes no sense, because that's not going to fix the defaulting owners. It's just going to patch the problem, and in 2 years' time you're going to have the same issue, and you haven't actually fixed the core of the issue. So again, I digress. Let's assume that the trustees took out this loan, didn't tell the owners, and the owners are appalled by this because none of them would have ever voted in favor of this, then you might have recourse to be able to declare the agreement void. Typically this happens, especially, well, obviously it is void because the decision wasn't properly made, so there's no authority to enter into that contract. Problem is that a lot of situations in our law protect third parties who may come across as innocent because they genuinely didn't know. So if for some reason it would appear that the lender genuinely didn't know and assumed that the right authority was passed, it could be a bit of a problem. If, on the other hand, you can come right to declare it void, the other downside is you do still have to pay back the capital amount. So worst case scenario, you've got an agreement you don't want. A best case scenario, you still have to pay back the capital amount. So if the trustees have used it up, you're already sitting with a bit of a problem. But that's a conversation for another day, whether the NCA can be applied to these specific type of loans. But that is quite a long story because there's different views and versions of this. The general view consensus is it should be able to apply. The lender does need to be registered as a national credit provider. The threshold is 0, so any loan would apply. But yeah, that's something that we need a bit more time to go through, but it is something to consider as well.
Thank you, Bruno. Thank you, Cilna, for this valuable information. We've run out of time for today's session, but there was a question that was asked by Ricky Kwan. Ricky, I have noted your question and we definitely will be raising it at our next forum or next webinar that we're having. And to our viewers, thank you again for joining us. It's always a pleasure to have you with us. And please post your questions in the comment section or on the group itself, and we definitely will get through to it. Today was a jam-packed session. We covered quite a bit of topics. So apologies if your question was not answered, but we definitely will make time for it as we progress. As always, thank you, Cilna. Thank you, Bruno. And thank you to the viewers. Please tune in next week, guys. We really, really have a lot of fun, answering your questions and tackling the concerns and issues that you raise on a weekly basis. Thank you, everybody. Thank you, Cilna. Thanks, Bruno. Cheers.
Thank you.
Cool.
Bye-bye.
Cheers. Thanks, Chris. Cheers.
Cheers.